if I can ask everyone to be seated, because all I'm known for is making the trains run on time at these conferences. I want to begin this panel by introducing someone who's not on it. Out there in the third row is Judge Anita Brody, who is the judge who's handled the NFL concussion case. We would have loved to have her on the panel, but there are some legal niceties because there are motions to be made and decided and appeals to be taken, and it's more appropriate that she maintain a respectful silence until there's clear error stated, in which case she has a right to intervene. I want to assure her she has the right to correct clear error. Okay. We also have one other member of this panel. You were hearing at lunch about the brooding omnipresence in the sky. Well, this panel has a brooding omnipresence in the sky up there, and we're delighted to have Judge Rosenthal from the Federal District Court in Houston. And Judge Rosenthal served many years on the Federal Rules Committee, chairing various subcommittees, and is a person who knows everything there is to know about class action practice. Okay, that's our backdrop. I want to start this panel at the obvious place, which is with the plaintiff. But first, just let me say, this case starts back in 2011 when something like 73 retired NFL players sue the NFL, alleging that the NFL had hidden or not disclosed adequately the connection that they allegedly had long known about between concussions and later stage cognition loss through dementia, Alzheimer's, or whatever other consequence. That is the core theory here, that somehow there was a connection that was not adequately disclosed to players. All right. Now, at this point, these cases get filed in California. Pretty soon, some cases get filed in federal court in Pennsylvania, and someone moves to consolidate. Well, the defendants move to remove the cases to federal court, and someone moves to consolidate everything before the judicial panel on multi-district litigation. And that's how an awful lot of cases start out. But I want Chris Seeger, over to my left here, who is the plaintiff who took over this case and carried it to a, I think from your standpoint, a very successful conclusion. I'm sure you don't blush at saying that. We'll have other people raise their concerns, but I think you're happy with this outcome. And tell us how it got started and how you got put in charge.
Well, I mean, the case, so I was thinking, how far back are you talking about the appointment of lead counsel? And
That's what I'm talking about, yeah.
So in the beginning, there were a lot of lawyers involved. I mean, the case was kind of, with the plaintiff's bar, had been kind of bouncing around since 2010 and even before, because the issue of concussions came to light with some reporting that was done on ESPN, I think by the Faineru brothers, and the problems that players were being faced with. So I think a lot of plaintiffs' firms were looking at it at that point. I think a lot of firms began to look at the case around 2010. In 2011, as you said, Professor, a group of lawyers started filing cases, I think in state court in California. Brad Karp and his team began removing them to federal court. We wound up in front of Judge Brody, that the panel sent the case to Judge Brody. And, you know, as is typical in litigations, the plaintiffs' lawyers got together and, you know, sometimes they fight over leadership roles, sometimes they can get together and agree. There was an agreement early on to submit a slate to Judge Brody that involved maybe 5 or 6 firms that would essentially serve as an executive committee. Judge Brody didn't like that. I don't want to speak for you, Judge Brody. You're sitting right here, which makes it, I have to be really careful. But I don't think Judge Brody liked the idea of that many lawyers. My interpretation of what Judge Brody did is that she didn't like that many lawyers in a leadership role. I think she wanted to give that over to...
We need a camera to focus on Judge Brody so she can scowl occasionally and give us a full... And that won't go into the record.
I think she wanted it to focus on a couple of... She did a lot of research on the lawyers that were applying. I think she wanted to focus it in the hands of 1 or 2. And she had appointed my firm and Saul Weiss's firm to serve as co-leads in the case. Mm-hmm. You know, it's an interesting case because, as many of you know by now, the case ended as a class action. It didn't really start as a class action, started more as a mass tort, which means that you not only had lawyers involved that were, you know, representing players, but you had really potentially thousands of individual cases that could be filed in the court before Judge Brody. That actually sounds like a mess, and sometimes it was. It's difficult it was a little bit like herding cats and getting everybody involved. Obviously, it creates issues when you're trying to negotiate a settlement. I'll tell you, just to jump around a little bit, if you don't mind, one really, I think, good and interesting dynamic that came out of that is that at the end of the day, when you're stressing out, you're doing a class action over the structural protections that will protect players and the different interest players have. This particular case had a lot of structure in place. I mean, not only was Judge Brody very active in this case, and many of you know, if you know the history of this, that she rejected our first attempt at getting the case settled. She rejected the case at preliminary approval and forced us to go back and renegotiate. But she had court-appointed special masters who assisted in negotiating. We had subclass counsel. On top of subclass counsel, because there were about 5,000 individual cases filed with lawyers that represented them pursuant to a retainer agreement, we had the eyes of potentially another 300 lawyers representing individuals that looked at the settlement agreement. So there were, at the end of the day, when you think about and you stress out over AmChem issues and the structural protections, there was a lot of structure in place in this case. So that actually, I think, turned out to be a tremendous benefit that there were that many lawyers involved that could scrutinize this and ultimately sign off on it and accept it. I mean, once the case was approved, there were very few opt-outs. It was a very small number. And even though the opt-outs were slightly, they have a class size of about 20-something thousand, there were only about 200 and change that opted out. By the time we were finally approved up through the Supreme Court denying cert, that number came way down to maybe, I could be a little off, Joanne, you may know it better than I do, but 150 players ultimately remained as
There were something like 17,600 or something, I think, who opted in ultimately. I mean, who filed for the class.
It was a
so
B3 class.
17,000 is the denominator. Whatever number you're talking about is not more than 1%.
It was actually, I think it was closer to 22,000, not to quarrel over numbers, but it was probably closer to 22,000, which also brings to mind another interesting point that again, jumping around a little bit, but the things that I think are important and I'm very proud of in this case is the fact that players began to register for benefits in this case long before the registration process even opened. By the time the case was in the Third Circuit, we had close to 7,000 players registering in a process that was not formally opened yet. So they were interested in the settlement and the benefits that I provided. Once the case was final and registration formally opened, we had about 20,000 registrations. Now, some of those involve derivative claims, but the participation rate in this case is extremely high, which I think says a lot about the settlement.
I would like now to go to Judge Rosenthal and give her a hypothetical question. And the hypothetical question is, imagine this. The JPMDL, Judicial Panel on Multi-District Litigation, mulls over what to do with this, and they send it, for whatever reason, not to Philadelphia, but to Houston, and they give it to you. And you suddenly find that you're going to be an expert on the NFL. At this outset, as was just said, you don't really know whether this is going to be what I'll call a mass tort consolidated proceeding or a class action. And frankly, probably most mass tort cases today are not certified as a class, but are instead dealt with through the consolidation procedure, and there have been millions, literally millions of asbestos claims have gone in that fashion. So you have this choice, and maybe it's not entirely your choice, but you have a lot of influence over this. What do you think about, what questions do you ask? What do you want to know, Judge?
That's a really good question. And it's not completely out of the ballpark, no pun intended, and I guess that reference by itself reveals how little I know about the different kinds of ball. And I suspect that the choice of sending it to Judge Brody or me would both be a choice to send to some of the few people in the world who care little about football as a sport and care a lot about the rules of procedure. That's not a common combination. But I suspect that Judge Brody, with whom I had the honor to be in baby judge school, we go way, way back, and I share those characteristics.
Wait a minute, just a couple of years ago in both cases.
Yeah, right. And your question, in light of the panel and the audience, really requires me to engage in a fair amount of chutzpah. Judge Brody's in the audience. She was on the ground. She made the difficult and brave decisions against a backdrop of uncertainty of both substance of law and the procedurally best and proper way to handle this that would withstand not only the lawyer scrutiny that Chris has talked about, but the appellate review process as well. Professor Klonoff was an expert for the class counsel advocating the settlement. Chris Seeger did very well while doing a lot of good. Elizabeth Cabraser as well. Alan Morrison invoked the ALI principles of aggregate litigation in his amicus briefs on behalf of objectors. He's in the room. Sam Issacharoff and Bob Klonoff together know more about the principles of aggregate litigation than anybody else on the planet. And Mr. Karp represented the NFL. I was not in the room where it happened. I do not have the benefit of that information. So I'm going to launch where only the foolhardy would tread in response to your invitation to leap in with both feet. So the first thing I thought of was imagining this song from the movie from the 1980s. You remember it, Ghostbusters. When you have a bunch of ghosts in a building in New York, who are you going to call? You have a result you want to reach. And I suspect that everybody in the room, when the cases were at least brought to Judge Brody, had in mind some kind of mediated resolution by settlement in whatever procedural form was required to get there. And there were a lot of looming substantive law questions that first had to be answered. The first question, though, was whether it was necessary to answer that question, specifically the issue of preemption, in order to decide how procedurally to package the case to get to the next step. And Judge Brody made the decision that, as is often the case, ordering the parties to try to resolve it in the face of the uncertainty created by conflicting decisions with unclear law on the preemption issue, the substantive issue, was the most likely to lead to an agreement to agree, rather than coming down on one side and triggering the appellate process that would have delayed everything and made perhaps it at least a longer process to any kind of resolution, if not a more difficult one, impossible to second guess that choice. So if you look at the MDL manual, which is a scrawny little volume that goes back a long way, for guidance, 10 steps to better case management issued by the MDL. And they're fine. They're wonderful. Question is whether they go far enough in giving guidance to a judge who is in an industry and an area of medicine about which the judge knows nothing. And is trying to figure out what the best procedural posture to withstand appellate review and get to a good result is going to be. So the judge, as best I can tell, did exactly what the manual says. Promptly schedule a conference. Take great care in appointing counsel. Check, check. I would have done just the same thing. And no one questioned, not even the objectors who questioned class certification, who questioned the adequacy of representation, who questioned the settlement process. No one questioned the professional competence or expertise or the good faith of the lawyers. So would I have done anything different in two ways, really three ways? First, certify versus kept the sort of inventory structure. Second, made a more searching inquiry. And how, if I had decided one was appropriate, into the nature of the different claims that the plaintiffs were purporting to present by way of representative plaintiffs or if the case hadn't been certified, would have been presented by the way in which counsel in the steering committee or liaison committees packaged the various claims for consideration in the settlement process. And the third is, what procedure would I have put in place and what standards would I have employed to approve the proposed settlement terms? Well, the first thing that's fascinating to me, and someday, Anita, within the cone of the sisterhood, and I will buy the wine, I would love to know the basis on which you decided to reject the first proposed settlement, which would have been presented as a proposed class basis. I don't think it was because it was a class versus a non-class aggregation, but rather a concern over the size of the pot and the existence of the cap. And my first question, since the record doesn't really disclose evidence of going outside and making an independent inquiry that would have told you in any specific terms that would have been why the amount was going to be inadequate and under what circumstances, under what assumptions. If I knew more about the record, I might have the answer to that question. But figuring out to reject that first settlement and move on to appoint a mediator, very talented former judge, who got the parties together, and 5 months later you had a cap-free, but in the eyes of some, Alan Morrison in particular, inadequately revised in other respects, settlement package that went forward. So then the second question is, certify or not, aggregate or not. At the end of the day, this may be one of those cases that, for the reasons Sam Issacharoff points out in his article on participatory class actions, may not have made much difference. Because in order for me to have been comfortable treating this as a non-class action, I would have had to be satisfied that I had the authority as a supervising judge, if you will, to ensure the structural assurance of fairness that Chris referred to. Reasonable minds can differ as to whether the structural assurances of conflict-free, adequate representation for sufficient categories of injured people within the future, the diagnosed, non-diagnosed classes that were recognized. Reasonable minds can differ as to whether that structure was sufficiently divided with enough different representative plaintiffs and separate counsel to provide adequately protective structural assurances of fairness. But whether you did this as an aggregate litigation or as a certified class, I think that the principles of aggregate litigation would have been the basis for me to look for guidance on how to try to substitute assurances of fairness if I was to proceed on a non-class basis. And the reasons for rejecting a class basis, again, without the benefit of reaching out for additional insight into the nature of the disease, the nature of the injury manifestation, the likely timetable, the adequacy of those present in the room to speak on behalf of all the varieties of likely affected claimants. The best way to get that input before accepting a proposed settlement, aggregate or certified class, I think the outcome would have been the same. And the certification obstacles, I think, were primarily those identified in Ortiz and Amchem. I mean, to the extent the argument was, take this because this is all the coverage that the defendant is likely to pay, that sounds like a limited fund argument. Or Amchem, we have diagnosed and not diagnosed. Well, everybody knows, everybody in the futures class knows whether they were exposed. So you don't have the most difficult future problem of an ANChem, but you do have a lot of uncertainty about some future claims and the trade-off of past injury claimants and future unknown injury claimants. And that raises all the usual AmChem issues. So at the end of the day, I think I would have wanted to get some additional information, and whether I did it through through discovery, whether I did it through allowing the objectors to develop a record and propose an alternative approach procedurally or structurally, whether I would have modified the settlement approval procedure by requiring all of the grounds for approval to be filed in advance, requiring any objections to be filed, then make a separate decision on whether to have discovery on any of the bases for objection, and then make a separate decision on whether to allow evidence at an adversary hearing. Even though there are only 200 objectors, they are vigorously and well represented. And that would have raised the question at that point of whether to approve and on what procedural and substantive terms. So that would have been my approach, but at the end of the day, I think there would have been a mass approval. Whether the terms would have been identical and whether the structure would have been the same, rule or extra rule, might have changed. But those who are the claimants we know today, I think would have received the benefits that would not be wildly different from what they have received. That's my instinct, and that is all it is. And again, thank you for letting me appear in Ghostbuster qualifying fashion to deliver the thoughts through the ether. And it sounds like you've had a great discussion. I wish I had been there in person. Thank you.
Well, thank you, because that was really an elegant presentation that was both cogent, condensed, and got an awful lot of law and policy into a very simple presentation. I want to emphasize, sort of just restating, the two principal points that I take away from what the judge has just said. One is she sort of suspects that the parties were happy with the mediated resolution, and the early planning was to make it more feasible and possible to get a mediated resolution rather than a quick resolution on summary judgment or direct or dismissal on one of the issues. So that's a question I'm going to give to Brad in just a moment. Mediated resolution being desired by both sides rather than a complete all or nothing victory. And your second point was really, if you use the right structural assurances, you can get to the same outcome, either by a class action or by the aggregated resolution. There might have been some reasons why you avoid some of the ANChem problems in class certification, which, by the way, this case is in the Third Circuit, which was the jurisdiction that ANChem came from, and where I think they still remember Judge Ed Becker, who wrote that decision, who in my view, one of my legal heroes is Judge Ed Becker. Okay, so we have two ideas here. And on these, I want to turn first to Brad Karp. There is a suggestion here that although you had lots of defenses that you could raise, you had some powerful defenses about preemption, you had an arbitration clause, and we know the current Supreme Court loves arbitration clauses, but you didn't press for an immediate victory. You were happy with some mediation, and maybe your client saw some advantages to a mediated outcome. Can you comment on that?
Sure. This was a very unusual case, as you might imagine, for lots of different reasons. This case attracted, this issue, even before the case, attracted a lot of public attention. And the public attention was not good for my client. The risk of cognitive impairment as a result of playing professional football is one of those rare existential threats to this particular client. And when the lawsuits began trickling in and then cresting in a tsunami-like fashion, you realize that at the end of the day, there are 22,000 retired NFL players, all of whom would have been exposed to the allegations that plaintiffs had raised about the risks of playing professional football and the alleged linkages between playing the sport and suffering cognitive impairment, and litigating those cases in whatever manner they are to be litigated is not putting the league in a very enviable position as a public relations matter. It's obviously putting the league in a very difficult position as a litigation defense manner as well. And one of the big issues at the very outset was to figure out what is the end game. I mean, one of the things that defense counsel always have to figure out the moment a matter begins is what is the outcome that you realistically are hoping to achieve. The league historically had engaged in scorched earth litigation. They fought everything in every context, decade after decade after decade. And I was advised by senior officials at the league that resolving a case consensually is not in the ownership's DNA. So that was a practical obstacle that had to be dealt with. And when you think about a corporation, you think about a CEO, a board of directors, a general counsel, and that's a familiar structure, and it's one that you know how to deal with. When you think about the National Football League, you think about 32 independent, co-equal owners who really control the NFL. And you have to figure out how are you going to communicate with this body and be persuasive if you believe that the best outcome is a resolution, a consensual resolution. How do you communicate it to this body that has never really attempted to resolve a matter consensually before? These individuals became owners because they've had a fair deal of success in their personal and professional lives, such that they are billionaires and own professional football teams. So one of the issues was a structural issue at the outset. How do you get the general counsel of the NFL, the commissioner of the NFL, and the ownership body to buy into the notion of a resolution, if that's what you believe is most appropriate? I believed it was most appropriate. We were able to convene a subgroup of the ownership, 6 owners who would be the representatives of the aggregate ownership group, and we can speak to them, work with them. If they bought into the notion that at the end of the day, a resolution, if it were possible to achieve, made the most sense, we could try to persuade the entire ownership. I have not yet answered your question.
Keep on, you're doing great though.
The issue that we had to structure was, assuming now that we can get the league on board, how do you settle this case? You have all of these matters, they're all pending before Judge Brody as part of the MDL. You have hundreds and hundreds of lawsuits involving thousands and thousands of players. We have a lot of defenses. You ticked off a couple, but preemption was a significant defense. Statute of limitations was a defense. Causation, assumption of risk. You could go on and on. There were a number of potential defenses, all of which had risk for us, all of which had risk for plaintiffs. But at the end of the day, the goal was put this matter behind the league as completely as is practically possible. And in order to do that, we needed to have an overarching resolution. The judge scheduled oral argument on the preemption motion and heard oral argument on the preemption motion relatively early on. The argument went on for several hours. Judge Brody reserved decision. We had a view about how the argument went. Chris Seeger and his team had a view about how the argument went. Both sides had risk. When you're a defendant and you're looking to settle a bet the franchise type matter, you're looking to find whatever leverage you possibly can in order to try to persuade the plaintiff to be as reasonable as possible. Judge Brody, as Judge Rosenthal mentioned, used the tactic of taking one of the dispositive issues in the case and having it hang over both parties' heads. It was very effective. It got everyone's attention. Chris Seeger, who was the key plaintiff's counsel, the lead counsel, has a terrific reputation in the community. He is someone who is trustworthy, who is reputed to be trustworthy, and in order to settle the case, Chris Seeger and I had to be able to have very candid discussions. We didn't have a lot of time. There was a pending motion that would really change the leverage dynamic in a very dramatic way. Judge Brody had indicated that we did not have a lot of time, so we began to have some very candid discussions about what Chris needed on behalf of his clients and what I thought was achievable on behalf of the NFL. We had the discussions initially one-on-one, and we made a great deal of progress, but we reached out to Judge Brody to indicate that we probably needed a little bit of help given all sorts of external dynamics that were at play here. Every move that was made in this case somehow found its way into the public press. So there was a lot of pressure, and we thought a mediator working under the supervision of Judge Brody would be effective. Judge Lane Phillips stepped into that role. Judge Brody appointed Judge Phillips to play a helpful role.
Can I ask you there, he's a very well-known judge. Phillips is an expert mediator, done it in many cases. Was this a case where the parties chose his name and suggested to the judge, or did the judge start from scratch and say, here's the person I want as the mediator?
We had a discussion about who would be an appropriate mediator. I think
this was a name you'd already discussed to some degree.
Yes, to some degree. And obviously it was up to Judge Brody to weigh in and ultimately bless his appointment. We had an intense period of mediation, again, with the judge about ready to decide the preemption motion, and that really forced both sides to get pretty quickly to their bottom lines. And, you know, as in any settlement, think of it as a Venn diagram. You know, we have our settlement position, plaintiffs has its settlement position, and you're hoping to find some shaded common ground. And ultimately, we found that little sliver.
There's no blackboard. I would have drawn a Venn diagram, but there's no blackboard today.
Yeah, and we found that little sliver of commonality, and we went to Judge Brody, and we indicated that we think that we are in a position where we can move forward. We couldn't obviously get the court's blessing, but we wanted to share our thinking with the judge. The judge played an incredibly active role in superintending this case. And the only reason it's settled is because Judge Brody played such an active role. Without her being fully engaged as needed and often on a daily basis, this case would not have been settlable.
So the message here really to other trial judges out there is that if you've got a very important case with huge consequences, put your gun to both sides' heads and tell them they have a short time to get to at least a term sheet level of agreement.
Correct.
Let's write that. That's to be added to the manual for multi-district litigation. Okay. Now, do you want to go any further on that, or?
Whatever you'd like.
Well,
I mean, we
I'll
could
come
come
back.
to the very painful part about
there was a reference there from Judge Rosenthal to working out a settlement that met the Issacharoff principles of participatory class action settlement.
And Elizabeth, my co-authors.
We're going to get to both of you, but I want to start with Sam and say, one of the questions that maybe the whole room isn't clear on is exactly what would be the differences between settling on an aggregate individual basis and settling on a class action basis. And in particular, do there tend to be settlements that have more variance, more individualization in the mass tort aggregate setting than in the class action setting, where there might be more of a one size, not one size fits all, but a more limited number of outcomes?
On that specific question, I actually don't think there's much difference between a class settlement and an aggregated settlement of an inventory of claims through the MDL. Both of them, if the numbers are sufficiently large, will develop a grid structure and figure out compensatory schedules in which people more or less fit. The fits are always going to be imperfect, but you try to get pretty good justice across the board. The difference between the aggregated and the class is the level of preclusion you get. You're buying a greater amount of preclusion. And one thing Brad didn't mention, I'm not speaking out of school, he's mentioned this, and we've done this in public many times, is that at the very beginning of the negotiations, one of the NFL's demands, and it seemed non-negotiable, was this has got to be a class settlement. My client wants closure, because that was the only thing that Brad came back to say that his clients insisted on as the sine qua non. If he doesn't get that, we don't start. So the question, to my mind, from the beginning, I was brought in by Chris right early on when he was appointed, and then started playing an active role once there were any kind of settlement discussions. The key question was, how do you get that level of closure which could induce the NFL and its ownership structure to the table? And I think in candor, if this had been 15 years earlier, we wouldn't have been there. 15 years earlier, the entire bar and bench in this area was reeling from the initial implications of Amchem and Ortiz. And the conclusion was it can't be done in mass torts, it can't be done with anybody who hasn't fully manifested yet, it can't be done with the kind of variation that we had in the class in NFL. And that was 15 years earlier. And our approach in going into this process was to look at where the law had moved in the intervening period to see where the room was. And in particular, as you mentioned, Jack, we were in the Third Circuit. So the Third Circuit had had a big en banc on the range of class action permissible settlements, a case called Sullivan versus De Beers. I argued that case. And in the result in that case, there was a concurrence by Judge Sirica, who's in the audience today. And what I told Chris from the beginning was, we're going to run this through the heart of Judge Sirica's concurrence, because the concurrence asked the following question: have we really advanced the ball in fairness, efficiency, equity, if we are forcing all these cases into these semi-obscure aggregations with imprecise rules, or are we better off perfecting the class action mechanism and getting independent bases of structural assurances, with all this language that we take from Amchem? Is there some way of doing that better with within the class action framework? And I think that we came up with a number of mechanisms in this case, which may be a blueprint going forward, but I think that we went about it quite self-consciously, quite deliberately. We thought we were faithful to this language from the Third Circuit. And the keys, to my mind, in it were, first of all, that the representation of absence depends upon how absent they are. And so Elizabeth and I have written an article about this notion of a participatory class action. As Brad said, we had 5,000 people independently represented. What were we going to create more little subclasses for? We already had, in effect, 5,000 subclasses. We needed additional counsel to scrutinize, to eyeball the settlement. We had over 300 independent sets of lawyers fly-specking what we were doing, objecting to it in every possible way. And so the argument was that you need objectors, you need these subclasses, when you can assume that most of the affected class is truly absent and passive. When they are engaged and involved, that changes it. So when we were going up through the circuit and all the way through the cert petition stages, we kept updating the information for the courts on the number of players who had registered for the claims, even though the claims process wasn't formally open until the settlement was final. By the time we got to the Supreme Court, Chris, I don't remember the exact number in the cert petition, but it was like 14,000, 15,000 out of 22,000. So when the objectors, the petitioners for cert, were saying, there's all these absents who aren't represented, our response was, who are you to speak for them? They've all spoken for themselves. Over 3/4 of the class is already engaged. So that was point number one. This is a different kind of class action. Social media matters, the self-consciousness. You know, none of us knew we were members of the AmChem class, right? I don't go around saying one of the ceiling tiles when I was a kid in school may have had asbestos in it. If I play football in the NFL, I know who I am, and that's a big part of my identity. This is not a passive group.
And you know everybody else who played.
And I know everybody else, and we get together to play golf, and we get together for veterans gatherings, you know, all this sort of stuff. So so that was the first point. The second was, and since this is a conference in Judge Posner's honor, a line from a case of his from Reynolds versus Beneficial, which has parallel language in Third Circuit opinions, the importance of the judge as a fiduciary. And we have debated as academics, what does it mean? How can the judge be a fiduciary? That means having a direct duty of loyalty to somebody, and how can you have a direct duty of loyalty if you're a judge and necessarily impartial? Well, it turns out that the activity of Judge Brody in owning this settlement, and it wasn't always pleasant. Let me assure you from our perspective, I know from Brad's, that this was not a fun process some of the time. Getting your handiwork thrown back in your face is not, you know, it's fun when you're the teacher, say, no good.
The record will show
Redo it.
The record will show the judges smiling at that time.
But it wasn't so much fun. But the judicial ownership over it, the intense judicial involvement, the front loading of the record on even preliminary approval was a critical part of the process. And if you look at the appellate decisions, not just the final approval, but the Third Circuit heard argument on whether 23F permits an interlocutory appeal on the preliminary certification. You look at the record, and the court in both instances largely backs off of its normal skepticism because the judge was on top of everything. And so there was no sense that there was, that people were buying what Henry Monahan here calls forced indulgences, right? There was no sense that we were just pulling one over on the judge and getting this. So I think
the term is plenary indulgence, but to be Catholic,
no, but
know that.
yeah, but sold indulgences. It's the Martin Luther critique of the of the indulgences for sale, and so I think that what we aimed at was, if Judge Sirica in Sullivan was trying to give us an opening to revitalize the class action so that we could provide finality and closure for the defendant, and so that we could provide the sense of fairness. And, Alan Morrison objected to this all the way up, but we fought on this. We provided these mechanisms, and these players wanted it. And that combination of the responsible judge and the participatory quality, I think, was our game plan in the settlement process, and we ran that from day one.
Can I just add something really quick?
Sure.
I'll make it fast. But Sam is right on the money. The other thing is that happened in this case, and maybe it's a model for others. I mean, there's no one size fits all. Let's be honest, every case is different. But Judge Brody had appointed one of the objectors to serve as a liaison counsel for all the other objectors. He organized them. He got their thoughts together. He happened to be probably the best lawyer in the group. I hate to acknowledge that in terms of his briefing.
We were okay.
Yeah. No, but in the objector group, which ranged from the professional objectors to somebody who could actually put a sentence together and more than just the boilerplate objections, he was one of the better ones. He served as their representative. That was a big deal, because that, together with the front loading, when Judge Brody made us take our actuarial reports on both sides, make them public, give them to a financial expert, a former Kohlberg-Kravis partner who came in to the second part after the rejection, who knew financing, trust me, better than probably 99.9% of the people on the planet. He had it all, and the public had it. So when we got to the final approval stage, yeah, I made a presentation, Brad made a presentation, but most of the day was dealing with the objectors and letting them vet their grievances. And then after that, there was post-hearing briefing. So there was a lot of process and a lot of structure, which I think it's helped make this really successful.
Okay. Now, I've left Elizabeth out so far. And Elizabeth, this is one of those rare cases, extremely rare cases, in which you weren't lead counsel. And to the best of my knowledge, you weren't even on the steering committee.
I think she was lead counsel. I was working for her.
She was lead counsel?
No, I'm kidding.
Behind the scenes, pulling
behind the
pulling puppet strings. Okay. But you had a lot of clients. You had clients who were in this class, who were NFL veterans who talked to your law firm. And as you watched all this, did you have any concerns? Did you have a preference as to which way it was structured?
Well, so, sometimes people think that I am a class action lawyer because I've done some class actions. The truth is that I'm a personal injury lawyer and I represent tort victims. It's one of those, when I'm in a room of tort lawyers, she's one of those class action lawyers. When I'm in a room of class action lawyers, it's, she's one of those tort lawyers. So in NFL, we had probably one of the largest groups of individual clients. We were not part of the leadership. And so we were interested outsiders. And I don't think that I am ideological about whether everything should be a class action or a mass action or something else. But it has occurred to me over the years, being involved in major aggregate settlements and being involved in major class action mass tort settlements, that under certain conditions, particularly those involving evolving diseases or later exacerbated diseases, cases where there's going to need to be a long-term claim program, that it is particularly important as the most functional structural assurance for the clients that the court have ongoing involvement and enforcement. And the one pre-existing template that we have for that is Rule 23. It's possible to construct a template apart from Rule 23, an extra class action template, but that's an ad hoc process. It doesn't pre-exist. The district courts and appellate courts don't already know what their roles and functions are with that. And so when I looked at this process from the outside, as a skeptic, of course, and as an advocate for our firm's clients, what was most interesting to me was the transparency and the public nature of the development of the settlement. I'm sure it was painful for those involved, but it was happening in real time. It was happening in plain sight. We all had access to the information. We were watching. Sometimes you don't want to watch the sausage being made. We were watching the sausage being made, and we saw what the role of the judge was at the district court level, and we also saw what the role of the court was at the Third Circuit level. So what we knew was that this wasn't going to be a perfect structure that was going to perfectly suit all of our clients. No class action settlement, no mass action settlement, no inventory settlement, no aggregate settlement ever is. But in terms of offering the most ongoing structural assurances for the greatest number of claimants, this Rule 23 template was going to be the best possible fit for this case in terms of accountability, in terms of transparency, in terms of enforcement. And so at the end of the day, most of our clients are participants in the class action settlement. We have some that have opted out. No one size will fit all. It doesn't fit them. Whether they're better off or not, in or out of the class settlement, time will tell. We'll try to resolve their claims. This was a personal choice of theirs, and the class action gives that personal choice. I mean, to me, at the end of the day, the biggest functional difference between a Rule 23 and a non-Rule 23 settlement, if it's going to work, is just opt-in versus opt-out. The Vioxx settlement really was a Rule 23 settlement in everything but name, and the only difference was you had to opt in rather than you have to opt out. I think if that settlement were being redone today, it could be a Rule 23 settlement. It didn't have a long-term claim program, and that was the other difference. But I think we are going to be seeing more long-term, complex, mass tort, personal injury, wrongful death settlements going back to the future and utilizing Rule 23. In the diet drug settlement, which is a long-term Rule 23 mass tort settlement, we are very glad today that it is under a Rule 23 structure because we have had to go to the Third Circuit on a number of occasions. Maybe Judge Sirica thinks too many. But we have. You're still seeing them. But people are still being protected. They are still being paid under that program. They have a process. It is public. It is transparent. And it is enforceable. And so as it turns out, that was a very good idea, and it bucked the trend at the time. The trend was against such settlements. We were doing that in the almost immediate wake of Amchem and Ortiz. So I think we'll see more of this simply because, if we can get past the labels and ideology, and that's the lesson from the Seventh Circuit, you don't look at labels, you look at function. So that's one reason why I think the Seventh Circuit and the Third Circuit, in terms of repeat class action involvement, developing the law, are the twin pillars. The Seventh Circuit, the names, the labels don't matter. Function, efficiency, fairness matters. The Third Circuit has now a very well-developed jurisprudence of addressing long-term tort settlements and where the lines are between class action with Amchem and others. So, I don't know whether if an entirely different set of lawyers had been in charge of the NFL concussion case at the outset, whether it would have been a mass action or class action or neither a litigated case. Who can say? But I think that it has proven itself, the proof is in the pudding, and it's proven itself as a viable mechanism for the settlement itself. And I think it has also served to legitimize a renewed look at the class action mechanism for other major tort resolutions.
Well, Elizabeth, I'm glad that you mentioned diet drugs, because diet drugs is the case in which there was a sort of a step-like system, an escalator, that if you took diet drugs 20 years later, your situation could deteriorate to serious and ultimately fatal heart disease with symptomatic levels that showed where you were. And that settlement did permit you to move up the ladder. By the way, both Sam and I were class action, were expert witnesses for the plaintiffs in that case.
I was counsel.
Well, you filed something with me too, anyway. Just a disclosure point. I think that this was useful, and the Third Circuit already had experience with class actions that could have increasing compensation based on post-settlement deterioration of the condition. Okay. Now, I've left someone out so far. Robert, as the co-chairman of this conference, start out by telling us what your role in this case was, and then I got a question or two for you.
Sure. I submitted an affidavit in support of the settlement, talking about class certification and fairness issues.
So basically, you were being brought in. From which side brought you in? Both sides wanted the settlement, of course.
Yeah, Chris
Okay.
called me, but it was really, I think, was an effort that was jointly pursued by the plaintiff and the defense.
Now, just looking at class certification from the first year, the law student's perspective, you do have some problems here because there's a lot of variation between these people. Most of these people played football and possibly got their bell rung long before they got to the NFL. They may have had years in high school, years in college. There may have been, in some cases, damage and even formal concussions that were recognized and diagnosed. And other people never had a scratch on them until they left the NFL, and then years later, suddenly their mental cognition deteriorates. That's pretty high variation, and we know that some at the Supreme Court think that that wouldn't satisfy their view of commonality, or possibly predominance as well. So you did have an issue here on class certification, but we have a settlement. And it's one of the messages of this case that despite all that we say and all that Amchem and other decisions have said, settlement class actions are evaluated by the courts under a very different standard than litigation settlements. We'll see.
Yes, absolutely. And I think you look at the practical side And I really think Judge Posner's teachings are consistent with everything that was done in this case. And in fact, I think Judge Posner, had this been brought to him on appeal, would have blessed this case because of the facts and circumstances.
Well, I'm going to come there as my last comment. I want all you to evaluate that. But for the moment, we're getting along too well. We're agreeing too much, and that's got to end. And the only way to do that is to reach out in the audience and ask Alan Morrison. You were an objector. I bet you're still an objector. What do you say about all this unanimity up here that everything was great?
First, I have to figure out how to get my mic.
There's no need, Alan.
We're not listening. That one? Okay. First, I now know why this case was approved by the district judge and approved on appeal. After all, with Sam and Brad and Chris, they're very formal adversaries. Let me say a couple things. First, from the very beginning, there were two things that I did not oppose. I did not suggest that this was not a case which could be settled, we could have a settlement class. Second, I did not complain about the amount of money, both before the cap or after the cap was removed, because I simply recognized that I was in no position to deal with a question that the lawyers who were down on the ground actually dealt with. And we're in a much better position than I to know how far Brad could push his client to fund this. But I think it's important that a couple of facts come out on the table for the audience here. And the first fact is that this case there was no class action complaint until there was a class action settlement proposed. So we were not starting with a proposed class and then working off of that in terms of what the settlement was. The classes were defined, and there were two subclasses, people who were currently suffering from a limited set of injuries and those who could in the future get a limited set of injuries. And those were the two subclasses. All right. It's important, at least it was important to me, when I first looked at this, I saw AmCam-like problems, not between presents and futures, because that was not the problem that I saw. There was a grid, and there were 4 diseases on the grid for compensation, and there were subcategories within those depending upon the age at which the player was first diagnosed, and second, the number of years at which the player played in the league. In addition, so that gave you a whole set of different potential allocations of money. The numbers on the grid were not based on, as you would in a securities class action, numbers that you could ascertain any place. They were very large numbers, starting at 5 million, going down to 1.5 million. And as far as I could tell, and there was no evidence to the contrary, these numbers were picked out of the air as a matter of negotiation because they thought internally they added up to what was originally, $650 million. The second part was that, as I said, there were only 4 categories of diseases which got compensation. And according to the NFL and the players' own, the class counsel's own numbers, about 85%, some numbers 90, some numbers 80, were not going to get a penny under this settlement, no matter what symptoms they had and no matter what they were related to the class action, and to the injury. And my concern was that, in essence, class counsel was, excuse the expression, playing God. They were deciding who gets money and who doesn't get money, and they were allocating it among the people in the class. To some extent, that's always going to happen in the class. But here there were, in my view, substantial inter-class conflicts. And second, and I don't mean to pick on Elizabeth on this, but she couldn't object to the settlement in a way because she had clients who were both on the grid and off the grid. As many lawyers who talked to me had clients who were on the grid and off the grid. And if they objected to the settlement on behalf of the clients who were on the grid, or off the grid, they would be harming their clients on the grid. So one of the choices I had to make in this, because I thought that the problem needed to be called to the attention, was could I represent any member of the class to object without, because as soon as I did that, I had to sort of figure out which objection was proper. And I concluded that I couldn't, and that I had to proceed as a role as an amicus, which of course made me much more vulnerable because A, I had no rights, I couldn't appeal, and I had to go along with the other issues. The liaison counsel, this is sort of illustrative of the problem of why I was not convinced the structural protections worked. Liaison counsel had one major objection. He argued that the CTE, people who had CTE, should be covered. That was the only objection he raised. He didn't argue about the grid, about the arbitrariness of the numbers on the grid, or about any of the other people who were excluded and would get no money. And so while he did perform a function as liaison counsel, he could not cover the structural void that was there. And my feeling about the case was, yes, it should have been settled. And yes, there was absolute transparency. We knew exactly what was going on the whole time, and the judge knew what was going on, and the class members. But there was not a good way for the problem that I saw, sitting as an outsider, that 85% of the people were not going to get anything, and those people basically didn't have any lawyers who were representing them, because almost everybody I saw had people both in the on-the-grid category and off-the-grid category. And that was my concern. The class counsel said, look, we cured the AMChem problem. It's like the generals fighting the last war. The AMChem problem was presents versus unknown futures. That was not the problem in this case. Everybody who knew they were in the class, there was no problem, as somebody said before, about the asbestos falling down on somebody's head. You knew you were a player, just like women knew that they had silicone gel breast implants. That wasn't the problem in that case either, and I supported the settlement in the class in that case. And so my problem was not with the cap and not with the requirement of opt-out, but how to get it apparent that the class, the two subclasses, could not adequately speak for all the people who were off the grid, or for the players who were losing substantial amounts of money because of either age of onset or the number of years played in the league.
So under the heading of perfect being the enemy of good, because I think what you're pushing for is perfection. The consequence, if you had succeeded, would have been, I'm going to start with the consequence, and I'm going to go through some of your points, would have been to blow this deal up. Now, I can tell you that the NFL would not have settled this as an aggregate. I'm pretty confident of that, because they needed 100% peace, and I could go through all the reasons why the aggregate settlement in this case. Okay, so you would have blown it up for everybody, but that's, let me just, and I respect you, you know that, and I think the world of you. I don't mean that as an insult, but there's a lot at risk here, and there's a lot of people's lives at stake. My class representative was suffering from ALS, didn't live to see the end of this case. So, but let's just go through a few of the points. I mean, on the values, like Elizabeth says, I started out as a personal injury lawyer. I litigate and try mass tort cases. I try cases now. I have a really good sense when I'm negotiating what the values of a brain injury is and what some of the others are. I had also, and I mean, look, I don't mean to make this about me. It's not about me. But it goes to the experience of counsel. I had also settled on a class basis a brain injury case involving a drug in front of Judge Barbara Rothstein involving the ingredient PPA. So I had some experience in this area already, and so did some of the other counsel that were involved on the negotiating committee. So on the values, we didn't just pull them out of the air. You study verdict values. You go, there are surveys you do and get a sense of what, the case is worth and where those values. There is an analysis that we go through. Let me just speed it up by saying that. On the not going to get a penny, I don't know where you're getting the 85% from. That was never in anybody's actuarial reports. But even if you agreed with me on the percentage, you'd still be wrong, because a big component of the settlement is the baseline assessment program. That's really the glue, in many ways, of this settlement. The problem was that these players were exposed to head hits that could lead to conditions. We didn't, obviously mood and depression, and I can go into why they're not compensated, but the bottom line on that was there was no science that would have survived any kind of legal challenge to them on mood and depression and the other things. We compensated the biggest injuries associated with CTE, and the point I was going to make about the baseline assessment program. It's critical in this case. These are worth thousands.
Describe what that is
Yeah, the baseline assessment program is a state-of-the-art testing program that we negotiated with the NFL using the best experts in the world on our side. I'm sure the NFL believes they had the best on their side, where we put together a testing program that would catch as early as possible any of these conditions, these serious conditions associated with CTE. Each test is worth thousands of dollars, and if we incentivized all the players to go through it for two reasons. One is to head off a problem and try to detect this early and treat them. The second one is to be able to get the players who could be diagnosed now with early dementia. We didn't make them wait till full-blown, early dementia. We get them into the payment program, which can get them as much as $1.5 million immediately, which they and their families need. So I mean, and then
And every single person got an insurance policy over 65 years, that if they were one of the people who developed those illnesses, they'd be covered. And I think you're totally minimizing the insurance aspect of the settlement.
yeah, I mean, I know where your
Could
heart
one of
is
you
on this.
define CTE for the room?
Chronic traumatic encephalopathy is,
There,
and I'm
that
sure
one.
everybody
Now
in the
take
room has
that.
probably seen that in the press and is,
Not good.
oh, that, yeah. But, yeah, so, I mean, I just think that, again, Alan, you know, when one of your proposals in your paper was to, if we had followed what you wanted, we would have had to have class reps for almost, well over 20, maybe 30 subclasses. How do you settle that case? I mean, and who are you really helping at the end of the day? And, you know, there's another point you make. One other thing, and this is why I disagree, and I think it's important. On the one hand, you say there are cases that get settled on the backs of big injury cases. You made a comment earlier. But one of your proposals in the paper you wrote is in the NFL case, you say we could have formed a workers' comp program that would have paid very little compensation for the injury on the pain and suffering side, but would have covered medical bills. Well, that's on the backs of the ALS victims and the Alzheimer's victims and the dementia, which, trust me, I mean, there's a pain and suffering component that needed to be dealt with in the settlement. So
I think there was a misunderstanding or a difference between us and the objectors and the amici. And basically, we saw this as a way of advancing compensation for the injuries that were easiest to document as related to NFL exposure. So it was based on epidemiologic data. I was quite surprised when I came in that ALS, which I never associated with football beforehand, had the highest levels of correlation. That's why it's a terrible disease, but it's also, for proof purposes, for trial lawyers, that was the one that you'd want to go to trial on. And so that gets compensated more. We had two very active class representatives. One had ALS and died during the course of the appeals. The other one was a player who had no known symptoms yet. So he was exposed to everything. He was exposed to CTE, he was exposed to ALS, he was exposed to Parkinson's, dementia. It was all there. So he was a perfect representative of the fear of the unknown, that you knew this stuff was coming to a lot of people. You didn't know if it was going to be you, but you had a lot of reason to fear, and you didn't know what the form would be. And so we offered people like him an insurance policy going forward that would cover them if they had the misfortune. And if they died at 85 and had never manifested anything wrong, and an autopsy says after the fact that they had some of the brain protein associated with CTE, God bless them, they had a good life. You know, that was our pitch. That's the argument we made at every court. And, you know, that's not a conflict, that's a decision. And there's a difference between a conflict and difference. And that's what the initial court reactions to AmChem couldn't distinguish. And our approach in this case was to say, difference does not mean conflict. We as the lawyers were not out to benefit one group versus another. Our class reps were in a position that they represented the kinds of risk that everybody had. And, you know, they all were your players.
But the two more big points, though, about dealing with the AmChem issues, you know, so oh, I'm sorry. Go ahead, Your Honor. You want to
No,
jump
go
in?
ahead. No, Seeger, Chris, go first.
I'll make them fast.
Answer.
On the
Go
AmChem
first.
points, the monetary award fund here is inflation adjusted, so it's growing over time. Big point. I mean, it matters on a 65-year program. The other thing is this: we have a clause in the agreement that requires us to go back and revisit the science at some point. That's a critical point. I mean, this settlement lives and grows over the 65 years. So anyway, Your Honor, go ahead.
So my question is to both Sam and Elizabeth, and really the whole panel, because I hear in this rousing defense of the adequacy of the settlement terms, the fairness of them, the adequacy of them, and the importance of settlement itself to the well-being of the players and over time. I hear a lot of consensus around that in the front of the room. But what I don't have clarity on or hear agreement on is whether the same result could have been obtained outside the Rule 23 structure, or whether it would have been better in some ways, perhaps riskier, but better. And my question is, in what ways can we identify and learn from to go a non-certification route? Are we making it too hard or too easy to certify mass tort claims in the future by the example of this case, which essentially overturns the kind of a perceived wisdom that AmChem and Ortiz together put a silver bullet through the heart of the mass tort personal injury class action? That seems to be gone.
Well, one little qualification here. We just don't know. We just don't know.
So those are my
We just don't know what the Supreme Court will do. We think that they have accepted this case, but we never know when they decide to grant cert and say, quite possibly looking very differently, and not looking in a Posnerian way, but in a more Scalian way that, gee, this doesn't satisfy commonality or predominance. So I don't think the future is yet utterly clear. There is a path, but that path could get cut off. Elizabeth?
No,
Actually,
Brad,
I'm
one-
sorry,
yeah.
Joe, I'm sorry.
Yeah, I just from a practical perspective, I don't think this case would have been settlable for the NFL, but for the fact that we were able to secure something very close to global peace. Because if there were going to be hundreds or thousands of potential open claims, the NFL really would not have had an appetite to put in the structure, the cost, that would have been involved in settling part of this problem. The NFL needed a complete solution, or as complete a solution as was possible.
Yeah.
Let's go. Elizabeth first.
from the-
I'll get back to you, Elizabeth.
Yeah, just purely from the plaintiff's perspective, I'm going to pretend not to care at all about what's good for the NFL, and really I don't.
I believe that.
I believe you.
You know, it is a strategic and practical consider. Courts need to care. That's a court job. You need to balance the interests of the plaintiffs and the defendants in these deals. I would love to tell you that I had a better structure for this deal, and that it shouldn't have been a class action, and that it could have just as well been a mass action or something else. And maybe from certain perspectives that would have worked. But I think Chris mentioned the key to this, and this is something that we also learned from the Seventh Circuit jurisprudence of Judge Posner, who does hybrid classes and issues classes and remembers that programmatic and injunctive and equitable relief is a thing, and it's an important thing. And that is that you can do things for people in a programmatic way under a class action mechanism that you cannot
gonna
as
give you the
easily
first
do
chance to answer
in an
what Posner
aggregate
have
mass
done, but
tort
I'll get there in a
mechanism.
minute.
For example, the insurance program in this deal, and in diet drugs, the medical monitoring program, which, by the way, was certified as a litigation class before the settlement. So those things are naturals under Rule 23, whether it's B2 or B3. They are worth an awful lot of money. They are worth more than money to the people that are affected, and they can most easily be done under the auspices of a class action, because there the whole is greater than the sum of its parts. The defendants get a whole release, which is a good thing for them. They can make a decision. They can pay more money than they would have paid. And that's where I do care about what's good for the NFL.
It's a critical point. It
Okay.
helps us
Because
get more.
I want to get one other
if they'll pay
topic.
that
Can I-
piece
can I-
premium,
I want to get
we
one
want
other
it.
point covered before we get to the closing moments. I will get back to all of you for your final comments. But one of the unique features in this case, usually the district court, having heard this carefully negotiated settlement, simply throws in the towel and approves it. That didn't happen here. The district court didn't give preliminary approval. The district court said, I wanted more. And the original settlement was capped. I think the number 685 million was given, and it became an uncapped settlement. Now, I'd like to know a little bit more about how did that happen. It first of all hit defendants. I mean, plaintiffs can't really object to this, but defendants suddenly found a surprise. What was the reaction?
The league was very happy with that result.
No, I meant, how did,
I'm joking. It was, I've been doing this for 35 years. It was the single hardest, most difficult, challenging decision I've ever encountered. I was very confident that the judge was going to approve the proposed settlement. And as a result, the league was very confident that the judge was going to approve the proposed settlement. And when Judge Brody indicated that she was not going to grant preliminary approval, and indicated that essentially that in order for her to approve the deal, it was going to have to be restructured and no longer be a capped settlement, where we had some bells and whistles, but they weren't sufficient. It was going to have to be an uncapped settlement with additional fraud protections, because that obviously becomes much more important to the NFL when in an uncapped circumstance. That became, there was a moment when I did not know that the league was going to buy into this, because it put an enormous amount of stress on our actuarial experts and their conclusions, on our epidemiological experts and their conclusions, and all of the representations we were making to the owners about what we thought the case was worth. Now we're really going to be tested, because it's uncapped, it extends for 65 years, the science obviously is evolving, the judge maintains jurisdiction over the matter in significant respects. If all of a sudden these conditions really do become progressive, and you go from moodiness and headaches to level 1.5 dementia, level 2.0 dementia, Alzheimer's, Parkinson's, ALS, this could cost a lot of money. And we were on the hook. And that was a moment in time that was, frankly, very dramatic. And I think Chris Seeger was also very concerned that the deal would collapse for that very reason. At the end of the day, it made the settlement much more defensible in the appellate courts, because it solved most of the potential legal challenges. We thought we had something that was going to be successful on appeal, but you never really know. This made it, frankly, much easier.
But it introduced one element which I think that the law has not recognized, and reinforces the importance of doing this in Rule 23. Because the settlement is uncapped, and because it has such a long lifespan, 65 years, and so many decisions that have to be made, Chris, Brad, myself, we're buddies now for 65 years of case-by-case dispute. And we are going to have to resolve every single claim that comes forward in the next 65 years. I mean, somebody's going to take it over at some point, but the result is that if this were an aggregate settlement, you would create a non-transparent, made-up body to handle this in a way that we would do our best to make it as fair and all this as possible, but instead, we're under an Article III judge, and we will be under an Article III judge for the next 65 years, and what?
Possibly a different one, but anyway.
And we will be adversarial in every one of these determinations going forward, so it actually, now they look like cases. I mean, we have disputes now because of just that.
I want to deal with this from the standpoint of a judge, but the judge can't answer this question. However, we have another judge here. Judge Rosenthal, I want to come back at the end of the day to you. You're facing a decision where you don't think it's ideally fair. You really like an uncapped settlement, but you know it could kill the deal. And it's a difficult call. And what would you have done, and how would you have analyzed this?
I think that Judge Brody did exactly the right thing in saying, with this cap, I can't go there. Now, my question still is, would I have wanted to elicit, and how could I have appropriately elicited the right information from the parties or others before making that decision? And that's a really hard question. It's a question both about the substantive terms of the settlement and about the procedural structure that the settlement should have been presented under. Now, I take Sam's point absolutely to heart, that the best argument against mass tort inventory resolutions is the opaqueness, the absence of the formal supervision that the judge, under a fiduciary obligation, assumes to absent class members, and that the class counsel and liaison counsel similarly have duties towards absent class members that the case law has defined in ways that are more advantageous to the notion of a supervised, transparently disclosed details of the settlement than would ever be possible outside the Rule 23 structure. So the relaxation of the Rule 23 structure, and I do view it as a relaxation, to permit this certification for settlement purposes, I think is a vital step towards making it possible to settle cases that, if Amchem and Ortiz and progeny were, including some of Judge Posner's cases, were more strictly applied, could not have been settled within a certified class framework. And I don't think that's a bad thing. So at the end of the day, I come back to where I started. I think that had I done it procedurally differently, I wouldn't have come out in a materially different place. And I find it very hard to imagine a more practically beneficial set of outcomes than Sam has described, in part because of the personalities of the lawyers who are involved. I trust Sam to say that he will be a vigorous advocate for his clients.
We accept
And I
his promise
trust
to be around for 65
they-
more years, too. Okay.
Right.
We're-
No, I trust them both for their stamina and for their determination to be the best of friends while not agreeing on a lot. That matters.
Now,
I do raise one other question, though, that seems to me to be left open by this, and that is, what's the status of an issues class? Let's assume this had been resisted and it was an adjudicative class. Would it have presented squarely the question of, could this be certified as an issues class? And to get back to the whole question of what would Judge Posner have done?
Well, actually, I want to
Would
go
you
back to that
raise-
question, if I can, Your
Right.
Honor. We're a little short on
so
the
let me
time.
introduce that. Yeah, so what would Judge Posner have done? Could we have severed at the joint here in a way that would have permitted certification for adjudication as an issues class if we couldn't get there by way of settlement only?
Now, I want to phrase it this way, if I can. This was a symposium about
Please.
Judge Posner, and we've heard all day long that Judge Posner was a pragmatic man who cared about whether the facts were being well addressed and well served.
Right.
And I want our panel to tell us, what do they think Judge Posner would have ruled if this settlement had been presented to him as basically the Seventh Circuit all in his case? And I'm going to turn first to Bob Klonoff.
I think he would have approved it. I think on class cert, he takes a very pragmatic view. His pollution and consumer cases, I don't think he would have spent much time with a rigorous analysis of Amchem. I think this case is the polar opposite from the kinds of settlements that he struck down, where you have strong evidence of collusion, and you have a judge essentially rubber stamping the settlement. We've talked about the active role of the district court and disapproving at the preliminary approval stage, the uncapped nature of the case. And so I think all of the hallmarks are there for endorsement by Judge Posner. Let me just say very briefly, as tie back to the lunch panel, I think the opinion would have looked very different. We haven't spoken at all about the Third Circuit case. That was a 55-page opinion. Judge Posner, we produced 42 opinions in a total of 181 pages, or an average of 5 pages per opinion. So I think his NFL opinion would have been very short. Judge Ambrose's opinion presumed that the settlement was fair. I think Judge Posner would have given no deference, but would have really looked at it de novo. Judge Ambrose dealt with a lot of issues that Judge Posner wouldn't have touched, such as numerosity, clearly not an issue with 20,000 class members. Judge Ambrose's opinion is filled with long block quotes. One block quote is a page long. I challenge you to find any block quotes in the 40-some-odd Posner opinions. Similarly with footnotes, you wouldn't have seen footnotes. And finally,
Be careful, you have to give equal time to Judge Ambrose.
And finally, although Judge Ambrose's opinion is very, very scholarly, there are no memorable phrases. And I suspect that if Judge Posner had written the opinion, there would be phrases that we would have been quoting.
Yeah, I thought affirmed was a memorable word.
Yeah, exactly. We cared most about
So did Judge Brody.
I want to give at least 1 minute, just 1 minute to Alan. You might want to tell us why Judge Posner might have said this wasn't a good settlement.
So I have no idea.
Okay.
I think I've said enough, and I'll pass on the other things I was going to
Okay.
say.
Sam?
Had I been arguing this case in front of Judge Posner instead of in the Third Circuit, I would have stressed another feature of the case which has come into stark relief afterwards, which is if this does not go forward as a class action, we don't have the benefit of the All Writs Act. And in any 65-year tail on a settlement, you will need orders to protect it. We have some orders that are coming out now from the district court in this case, which are going to be up on appeal, I'm sure, but involving things like can the court order payments to be made directly to the players rather than to their lawyers? Can the court take supervisory authority over third-party litigation funders and the conditions that they impose on the players in this? This is all subject to the All Writs Act. If I had been arguing in the Third Circuit instead of in the Seventh Circuit instead of in the Third Circuit, and I drew Judge Posner, I would have pushed much harder on how this is absolutely indispensable for the supervisory powers of the court.
Good point, Sam. We have very few minutes, and I had 2 hands up that I promised to respond to. Arthur, you had mentioned your hand long ago you wanted to make a comment.
Well, I really have a question. I just wanted to clarify. Right? People are talking past each other. Because if I heard you right, Alan, you agreed it should be a class action. You weren't challenging any of the substance of it. You were saying there was a procedural structural problem with how the case was set up to be negotiated. And that it was such a structural problem, you couldn't even figure out who to represent without creating a conflict for yourself. So if I heard you right, that was where it was, and I was trying to understand what is it that would have solved your problem, which was structural. And if that was right, none of the things that were said from up here were responding to your objection. I just want to understand, am I hearing it right?
Why are you
What's
being a
the real
troublemaker,
issue?
Arthur?
So I finally got through to somebody. And the answer would have been not 20 subclasses, but at least one or more people representing the large groups of people who were not getting anything, and one person to represent, to argue the other side of the years in play and the years of onset. And we would have had better, and probably one for each of the diseases. But we're talking about 8 or 10 subclasses, and that would have, and had they been put in place before the deal was struck, the term sheet was out in August, and the class representatives were chosen at the same time the term sheet became public. So the notion that they were involved in the negotiations is not correct.
That's not correct what you just said, in fact. I think I mean, I don't know how long you want to debate this, but I can tell you that Sean Wooden and Kevin Turner were involved with us in the negotiations. That predates the term sheet.
If I understand the facts, there is no one who got nothing. Everyone got at least an insurance policy, which takes care of late maturing problems.
No, insurance probably for diagnosis, but not treatment. There's no treatment under the baseline assessment program. There's of some medicines that are approved. Am I right, Chris?
If you
But
get
they don't get treatment for a disease
If you're a
unless the
standard
disease
deviation
becomes
off,
put you on the grid, and then you get compensation, not treatment. So
There was
if that's
one
what you
more-
mean by
yeah.
an insurance policy. They certainly are protected from subsequent evaluations that they have a covered disease.
Okay. There is, lady in the third row, had a question a few minutes ago. You have the last question of the day.
So I think this is maybe a little bit more of a comment. You talked about 65 years under an Article 3 going forward that you would be adversaries. There's one other part to that that I think is a great protection, and that is that you are adversaries that will know each other. And that creates trust. It creates a discipline over this process where you have to be straightforward with each other. You will gain reputation from this adversarial position where you are going after each other again and again. If someone misrepresents, if someone is not fair, if someone is not straightforward, there's a discipline there that is not typical. That is another protection that I think is critical for this process.
Yes.
Folks, the train has now entered the station. We're at 4 o'clock, and I want to tell you this debate could continue, but upstairs at the cocktail party. And I want to thank the panel for what I thought was an extraordinarily interesting discussion. Thank you, Judge Rosenthal.
I thought I was re-arguing the
It was my pleasure. Thank you for your courtesy, and I will really miss you at the cocktail party.
Never changes.
Okay.
See you all
Those of you who
soon.
want CLE credit